Welcome, everyone, to Talk Testimonies. Today, we're doing a deep dive into, well, a really significant Supreme Court case.
That's right. We're unpacking a dispute about the proper way to serve legal notice on a foreign state, specifically Sudan, in a lawsuit brought by victims of the USS Cole attack.
And the absolute core of this disagreement seems to be how we interpret the Foreign Sovereign Immunities Act, the FSIA.
Exactly. Particularly that requirement that a mailing must be addressed and dispatched to a specified person. That phrase is key.
So our plan today is to start with the outcome, right? What the court decided.
Yes, let's lay out the result first, and then we'll really get into the weeds, dissect the arguments that were made before the justices.
Okay, sounds good. So the outcome. My understanding is this all stemmed from a massive default judgment against Sudan, something like $300 million.
That's the figure, yes, a very substantial default judgment. And the specific legal question that made its way up to the Supreme Court was this. Was serving the initial complaint on the Sudanese embassy, right here in Washington, D.C., actually proper service? Did it meet the standard set out in the FSIA, specifically Section 1608A3?
Okay, so that's the crux. Did sending it to the embassy count? Let's dive into those arguments now. Starting with the petitioners, the USS Cole victims, what was their main point?
Their argument was very much grounded in, the plain meaning of the words in this statute.
Just read the text.
Essentially, yes. They said addressed and dispatched to a specified person means exactly what it sounds like. The mailing needs the person's actual address on it, and it needs to be sent to that address.
Okay, pretty straightforward reading. Why did they insist on that particular interpretation? What was the factual hook?
Well, the key fact for them was that the Sudanese foreign minister, this specified person here, doesn't actually have an office at the embassy in D.C. So they argued sending the notice there just doesn't comply with the statutory language.
Yeah. It's
like sending mail to my cousin's house addressed to me. It might get near me, but it's not to me at my address.
Right. You're aiming for the individual, not just the building. Did they point to other parts of the FSIA to back this up?
Oh, absolutely. They looked at other service provisions in the Act and said, look, these parts reinforce the need for really strict compliance.
How so?
Their reasoning was sort of, if Congress meant for embassy service to be okay under this section, they would have said so explicitly, like they did for other specific situations in other parts of the law.
Gotcha. It's like Congress knows how to authorize service at specific places, and it didn't do it here. What about the return receipt? How did that fit in?
Yeah, the return receipt required by 1608C, they argued that whole requirement becomes kind of meaningless, or at least weakened, if just anyone in the embassy mailroom signing for it is considered good enough.
Makes sense.
The concern is, does the mailroom clerk really ensure it gets to the foreign minister promptly? Or does it sit on a desk? It undermines the proof of delivery aspect.
That's a very practical point. It really gets to whether the right person actually gets notified in time. Did they mention how other courts had viewed this precedent?
Yes, they definitely leaned on that. They highlighted that circuit courts had almost uniformly concluded that 1608 requires strict compliance. Not close enough, but actual strict compliance.
So they were pushing for consistency with lower court rulings?
Exactly. And they also touched on the function of embassies. Yes, they handle diplomacy, but they aren't meant to be like a catch-all mailbox for lawsuits against the entire foreign state.
Okay. And didn't the legislative history come up? Something about the Vienna Convention?
Yes, that was another angle. They pointed out that Congress apparently considered allowing service at embassies initially when drafting the FSIA.
Oh, interesting.
But then they specifically rejected that idea. Why? Because of concerns raised, particularly by the State Department, that it might violate the Vienna Convention on diplomatic relations, specifically the inviolability of diplomatic missions.
So Congress consciously moved away from embassy service. That seems significant.
It does. They also distinguished a UK case, Reyes, arguing it wasn't relevant because that involved serving a former diplomat, not the state itself or its active mission.
Okay. And one more point from them, something about Washington, D.C. being specified elsewhere.
Right. In Section 1608(4), which deals with service via the Secretary of State, it specifies Washington, D.C. Their argument was, well, if Congress specified D.C. for that route, it implies that for service on a foreign minister under 3, you should be aiming for their actual official address, which would typically be in their home capital, not D.C.
That's a neat structural argument. Anything else from the petitioners? Like, did the foreign minister actually get the notice?
That was a big point, too. They argued there was simply no evidence in the record showing that the former Sudanese foreign minister ever personally received the notice sent to the embassy.
Even if someone signed for it?
Even then. They questioned whether, even if maybe someone at the embassy knew about the lawsuit, did the responsible officials back in Khartoum know about it within the 60-day window before that huge default judgment was entered? That remained uncertain.
Okay, that's a powerful set of arguments, very focused on the text, structure, history, and practicalities. Now, let's flip it. Sudan, the respondent. They obviously felt embassy service was fine. What was their counter?
Sudan's core argument was, well, basically, the FSIA doesn't explicitly forbid sending the complaint to the embassy. It doesn't say you must send it to the ministry headquarters in Khartoum.
So absence of a prohibition means it's permitted?
Kind of. They argued the lack of a specific geographic requirement in PIRA suggests Congress intended some flexibility. And crucially, they positioned the embassy as an official address.
An official address of the foreign ministry.
Yes. They argued the embassy is, functionally a component of the foreign ministry. It's an official outpost. Therefore, serving the embassy is serving the ministry, in their view.
That's a very different conception of the embassy's role in this legal context. Did they look at other laws for comparison?
They did. They pointed out that lots of other federal statutes and rules allow service at various places, homes, businesses, etc. Their point was, when a law doesn't specify one single address, it usually implies a bit more breadth, as long as the method is reasonably calculated to give notice.
Which brings us to due process, I suppose.
Exactly. Sudan heavily emphasized due process. They argued the fundamental requirement is notice that's likely to reach the intended recipient. And, they maintained, the embassy is a direct, reliable communication channel to their foreign ministry. Setting it there is reasonably calculated to provide notice.
Okay, but what about the Vienna Convention concerns that the petitioners raised? How did Sudan handle the inviolability issue?
They brought up a 1958 revised commentary on the Vienna Convention. They tried to draw a distinction between the physical inviolability of the embassy premises, like police can't just barge in, and the simple act of sending mail there. They argued just mailing something doesn't inherently violate that inviolability.
A fine line, perhaps.
Perhaps. They also suggested, maybe somewhat contentiously, that many countries actually follow the U.S. State Department's preferred service methods, which they implied often involved embassies. And they felt the Vienna Convention wasn't clearly against service by mail anyway.
Okay. And they must have addressed the fact that someone did sign for the mail, right?
Absolutely. That was key for them, they stressed. A return receipt was signed at the embassy. That, in their view, constituted proof of actual notice. Sudan knew about the lawsuit.
And they also had a point about choice, didn't they, that a country could refuse mail?
Yes. They argued that under 1608, a foreign state could just adopt a policy. We don't accept service by mail at our embassies.
But Sudan didn't do that here.
In fact, someone signed the receipt. So they argued Sudan essentially accepted service this way in this instance.
It's like saying, we could have refused, but we didn't, so it counts.
Pretty much. They also pushed back on the idea that this was some radical departure, noting that while maybe unusual for lawsuits against the state itself, service by mail is sometimes used for suits against individual diplomatic personnel in some places.
Interesting. Did they address the reciprocity concerns raised later by the U.S. government?
Sort of indirectly. They noted the U.S. system has been non-reciprocal in allowing mail service where others don't, apparently without major diplomatic backlash or retaliation.
And what about the risk of default judgments if mail gets lost, even if sent to the home capital?
They pointed out that risk exists anyway, right? Mail can get mishandled even if sent directly to the ministry in Khartoum. Service is never foolproof.
Fair point. Anything else significant from Sudan's side?
Yes, they mentioned a State Department regulation related to the other service method, A4, service via the Secretary of State. They suggested that even that regulation contemplates the possibility of service potentially happening at an embassy in the U.S. And they argued Congress preferred A3 mail service over the diplomatic channel route anyway.
Okay, so they're trying to show consistency or at least lack of clear contradiction.
Right. And they slightly pushed back on the idea that no other country allows embassy service, suggesting the research might be incomplete. Their final point was sort of, look, allowing service at the embassy under a 3 isn't that big a deal because, again, a country can just choose not to accept it.
So if a country doesn't like it, they can just return the mail.
That was their essential position, yes. If they sign for it, they've accepted it.
Okay, quite a contrast to the petitioners. Now, we know the U.S. government filed an amicus brief, siding with the petitioners, the victims. What was the government's main thrust?
The U.S. government came out very strongly. Their headline point was, the United States itself does not accept service by mail at its own embassies abroad, period.
Wow, okay. Regardless of whether someone signs for it.
Regardless. They consider it improper under international law. They even describe their own standard procedure. If they get lawsuit papers mailed to a U.S. embassy, they send back a diplomatic note saying, essentially, this isn't valid service, we won't show up in your court, and we won't recognize any judgment you issue.
So a very firm stance based on their own practice and interpretation of international law.
Extremely firm. And they framed it heavily around reciprocity. The argument being, we shouldn't subject foreign states to service methods in our courts that we ourselves wouldn't accept in theirs. Treat others as you wish to be treated, basically.
Makes sense from a diplomatic standpoint. Did they have practical arguments too?
Yes. They echoed the concern about administrative burden, noting that attempted mail service on U.S. embassies happens quite often and is a headache.
Compared to serving the Secretary of State.
Which they said is much less frequent and easier to manage, partly because the U.S. has a dedicated Office of Foreign Litigation here in Washington to handle suits against the U.S. government. Serving the Secretary of State makes logistical sense for the U.S.
And they also distinguished another part of the FSIA, subsection B2.
They pointed out the subsection B2, which applies to agencies or instrumentalities of foreign states, specifically allows for service on a designated agent in the U.S. if one exists. Their point was, see, when Congress wanted to allow service within the U.S. other than through diplomatic channels, it specified how. The absence of such a provision for serving the state itself at its embassy under 3 is telling.
So, more evidence of congressional intent by omission. And how did the U.S. government address the Vienna Convention point differently than Sudan?
They really leaned into the idea that foreign nations would be affronted. They said receiving a legal summons via regular mail at their embassy isn't just like getting junk mail. It's official judicial process with serious consequences, and sending it there disrespects the diplomatic mission.
So not just a technical violation, but a matter of diplomatic respect.
Precisely. And they drew that distinction again. The foreign ministerial building in Khartoum isn't protected by the Vienna Convention, but the embassy in D.C. is. Service at the embassy improperly implicates the mission's inviolability.
And finally, the U.S. government strongly endorsed the alternative.
Yes, they heavily promoted Section 16084, using the State Department as the intermediary as the reliable, always available, and diplomatically sound method that completely avoids any Vienna Convention issues. The State Department transmits it through proper diplomatic channels via the U.S. Embassy in the foreign country.
Okay, so the court had these very distinct, well-argued positions. Text versus practicality, diplomatic immunity versus actual notice. Fascinating stuff. Now let's shift gears to our 10th chair perspective. If you were that hypothetical 10th justice, non-voting, of course, weighing all this, what stands out?
Okay. Sitting as the 10th chair, you really feel the tension between the letter of the law and the real-world consequences, both legal and diplomatic. The Vienna Convention argument, it has weight.
The inviolability point.
Yes. The idea of protecting diplomatic missions from becoming essentially legal intake centers for the host country's lawsuits, that resonates. Even if sending mail isn't, breaking down the door, it does impose a burden on embassy staff who might not be lawyers or equipped to handle it properly. It feels like it could strain diplomatic functions.
That's a fair point about the practical impact on the embassy itself.
Definitely. But then you pivot to the other side, and the argument that Sudan did get actual notice here, someone signed for it. Well, that's pretty compelling too, isn't it?
The purpose of service is notification.
Exactly. The whole point is to make sure the defendant knows they're being sued and can respond. If that actually happened, then, does insisting on a super strict, maybe even hyper-technical reading of the FSIA serve justice? Or does it elevate form over substance, potentially letting a party off the hook and denying relief to victims? That's a tough balance.
So you're wrestling with procedural purity versus achieving a just outcome based on actual knowledge.
Precisely. And that legislative history. Congress did seem to deliberately move away from embassy service because of those Vienna Convention concerns. You can't just ignore that signal.
Seems like Congress made a choice.
It looks that way. So at the end of the day, as the 10th chair, I'd be thinking about finding that balance. Respecting international norms, ensuring genuine due process, meaning actual timely notice, and maybe acknowledging modern communication realities. Perhaps the ultimate answer isn't just interpreting the existing words, but maybe Congress needs to revisit the FSIA.
To clarify things.
Yeah, maybe provide a clear definition of acceptable service methods on foreign states themselves, something that explicitly accounts for diplomatic sensitivities, but also ensures effective notification in a reliable way. Avoid these kinds of ambiguities going forward.
That's a thoughtful perspective, looking not just at this case, but potential future clarity. This whole deep dive really underscores how complex things get when domestic law bumps up against international relations.
Absolutely. A seemingly simple act like mailing a letter suddenly involves treaties, diplomacy, statutory interpretation. It's fascinating.
We certainly hope this breakdown has given everyone listening a clear picture of the arguments and the legal and diplomatic nuances swirling around this important case. It really makes you think, doesn't it? What is the best way to serve a foreign government? Should that strict statutory language always win, or does practical notification, actual knowledge sometimes matter more?
Definitely something worth pondering further. A real intersection of law and global politics.